Hello and welcome to the Minimum Competence episode for Tuesday, June 4th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, big law firms training associates on generative AI, Epoch Times CFO indicted, FTX's tax settlement, J&J's $260 million talc trial verdict, and a New York bill on sales suppression devices. Let's remember, we must beware of false knowledge as it is more damaging than ignorance, and read today's legal news. On this day in legal history, June 4th, 1928, the U.S. Supreme Court rendered a significant decision in the case of Olmstead v. United States, ruling that wiretapping private telephone conversations without judicial approval was constitutional. The case involved Roy Olmstead, a suspected bootlegger during the Prohibition era, whose phone conversations had been wiretapped by federal agents without a warrant. The evidence obtained was crucial in convicting him. In a 5-4 decision, Chief Justice William Howard Taft wrote the majority opinion, holding that the Fourth Amendment's protection against unreasonable searches and seizures did not extend to wiretapping because the amendment only protected tangible property and physical intrusion. Justice Louis Brandeis penned a notable dissent, emphasizing the right to privacy and warning of the potential for abuse and overreach in government surveillance. He argued that the Constitution should adapt to modern technological advancements, including the methods of communication. The decision highlighted a significant tension between law enforcement interests and individual privacy rights, a debate that has continued to evolve with advancements in technology. This ruling stood until 1967 when the Supreme Court overturned it in Katz v. United States, establishing that the Fourth Amendment protects people, not places, thus extending privacy rights to include electronic communications. The Olmstead decision remains a pivotal moment in legal history, reflecting the complexities of interpreting constitutional protections in the face of new technological realities. Big law firms are now training their summer associates on the use of generative AI, integrating it into their operations as a potentially transformative technology. Firms like K&L Gates, Deckert, and Orrick, Harrington, and Sutcliffe are incorporating training programs to teach associates how to use research and chatbot tools. These programs reflect a belief that while AI won't replace junior lawyers, mastering it will be crucial for success. Most firms are still experimenting with AI tools influenced by clients' openness to the technology. There's also a marketing aspect to the training, signaling firms' commitment to innovation and attracting top talent. Training includes understanding, quote, prompt engineering and utilizing AI tools such as DraftWise and Kira. Firms like K&L Gates are pairing associates with experienced AI users for practical training. Despite the advantages, there are challenges such as ensuring the accuracy of AI outputs and maintaining the firm's reputation. However, firms are increasingly embracing AI, with some developing internal tools like DeckertMind and partnering with AI startups like Harvey. The legal industry is recognizing the competitive edge provided by properly adopting generative AI technology. Weidong Guan, the CFO of the Epoch Times, was indicted on June 3rd on charges of laundering at least $67 million in fraudulent unemployment benefits. The indictment, unsealed by the U.S. District Court for the Southern District of New York, includes 2 counts of bank fraud and 1 count of conspiracy to commit money laundering. Guan, who pleaded not guilty, was arrested on Sunday and is being held on $3 million bail. The Department of Justice alleges that Guan managed the Epoch Times Make Money Online team, which used cryptocurrency to buy fraudulent unemployment benefits at discounted rates. These benefits were obtained using stolen personal information and transferred into bank accounts associated with the media company. The funds were further laundered through other accounts held by the Epoch Times. According to the DOJ, this money laundering scheme significantly increased the company's annual revenue from approximately $15 million to $62 million. In response to the indictment, the Epoch Times announced Guan's suspension and pledged full cooperation with the DOJ's investigation. The case is overseen by Judge Victor Marrero, and Guan is represented by the Federal Defenders of New York. FTX has reached a settlement with the IRS over $24 billion tax claim, significantly reducing the amount owed and facilitating customer recoveries. The IRS will now receive a $200 million claim payable within 60 days of FTX's proposed restructuring plan taking effect. Additionally, the IRS will get a $685 million lower priority claim, payable subordinately to customers and other creditors, depending on available funds. This settlement, filed in the U.S. Bankruptcy Court for the District of Delaware, resolves a major obstacle in FTX's bankruptcy, avoiding potentially lengthy and unpredictable litigation. FTX argued that if the IRS claim had been upheld, it could have prevented customer payments. The settlement provides certainty regarding IRS claims and allows the Chapter 11 cases to progress swiftly towards resolution, enabling prompt distributions to creditors and customers. FTX, represented by Sullivan and Cromwell LLP and Landis Rath and Cobb LLP, has stated its commitment to fully repaying customers. The settlement will be effective upon approval by a bankruptcy judge and the implementation of FTX's broader restructuring plan. On June 3rd, an Oregon jury ordered Johnson & Johnson to pay $260 million to Kyung Lee, who developed mesothelioma after allegedly inhaling asbestos-contaminated talc powder. The verdict, delivered by the 4th Judicial District Circuit Court in Portland, includes $60 million in compensatory damages and $200 million in punitive damages for Lee and her husband. The trial occurs as J&J attempts to settle most talc-related lawsuits through a $6.48 billion bankruptcy settlement. J&J maintains that their talc products are safe, asbestos-free, and do not cause cancer, citing decades of scientific studies. Eric Haas, J&J's vice president of litigation, stated the company would appeal the verdict. Lee, diagnosed with mesothelioma at 48, claimed she was exposed to asbestos-tainted talc for over 30 years, starting in infancy and later using the product as deodorant. J&J argued that Lee's illness likely resulted from asbestos exposure near her childhood home. J&J faces over 61,000 talc-related lawsuits, predominantly from women with ovarian cancer. The company has settled most mesothelioma cases, but needs support from 75% of remaining plaintiffs to approve the bankruptcy settlement, which would end ongoing litigation and prevent future cases. Previous attempts at bankruptcy resolution were rejected by courts. A group of plaintiffs recently filed a class action lawsuit to stop the settlement, alleging it misuses the bankruptcy system. The outcomes of talc trials have varied, with notable plaintiff victories and occasional wins for J&J. A New York state bill proposes to criminalize the use of automated sales suppression devices to evade state taxes, categorizing it as a felony. This legislation aims to increase tax revenue by up to $1 billion annually. However, critics argue that the bill could unfairly target business owners using common software tools rather than focusing on intentional tax evasion. The bill defines an automated sales suppression device very broadly, encompassing any software capable of falsifying electronic records, which could lead to frequent and unjust charges against business owners. The bill would make the use, manufacture, or sale of such devices a felony, with penalties including up to 7 years in prison. The expansive definition could even include software like Microsoft Excel if it could be accessed remotely. This approach contrasts with other states like Arizona, which criminalize possession of sales suppression devices only when intended to defeat taxes, imposing penalties rather than prison sentences. Critics suggest that New York's strategy mirrors problematic policies in the UK, potentially leading to criminal charges for business owners, even if they never successfully accessed a sales suppression device. Effective deterrence should target the actual perpetrators, that'd be manufacturers and designers of suppression devices, who often operate overseas and out of reach of state authorities. To combat tax evasion effectively, New York should focus on existing policies and technologies, such as conducting quality audits and educating business owners about sales suppression devices. Enhancing enforcement strategies and targeting the architects of tax evasion schemes would be more effective than imposing harsh penalties on local business owners who may be unaware of their involvement in tax suppression. Successful models from other countries, like digital invoices or sales tax lotteries, could also be adopted to improve compliance without resorting to extreme and draconian measures. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, a life spent making mistakes is not only more honorable, but more useful than a life spent doing nothing.